You are arrested. Before you are even in the car, an officer reaches into your pocket and takes out your phone. Your messages, your photos, your location, the record of almost everything you do. Can the police simply open it and start reading? For most of the smartphone era, the answer was unclear. Then in 2014, the Supreme Court gave an answer so blunt it became famous. If the police want to search your phone, get a warrant. For 200 years, the law had a simple rule. When the police arrest you, they can search what is on you. Your pockets, your wallet, whatever you are carrying without a warrant. It made sense when what you are carrying meant a few objects. But the device in your pocket is not an object. It is a window into your entire life. Over the next 12 minutes, the traffic stop that put the question in front of the Supreme Court, and the moment the court decided that a smartphone is different from anything a person has ever carried before. In 2009, a man named David Riley is pulled over in San Diego, California. The initial reason is ordinary. He is driving on a suspended license, and his car is going to be impounded. When officers search the car, they find firearms hidden inside. Riley's arrested, and during that arrest, an officer takes the smartphone out of his pocket and begins looking through it. What the officer finds goes far beyond the traffic stop. There are photos, videos, and contacts on the phone, and some of them appear to connect Riley to a street gang and to an earlier shooting. Later, at the station, a detective goes through the phone again in more detail, building a case from what is stored inside it. None of this is done with a warrant. Using the evidence from the phone, prosecutors charge Riley in connection with the shooting, a far more serious matter than how he was first stopped. Riley's case travels to the Supreme Court alongside a second one, very different on the surface. A man named Brima Worry is arrested in a drug case, and police use the call log on his simple flip phone to find an address. One case is a modern smartphone, the other an old flip phone. Together, they force the court to answer a single growing question. When the police arrest you, is the phone in your pocket just one more thing they are allowed to search? To see why this was hard, you have to understand a rule called search incident to arrest. For a long time, the courts have allowed police, when they make a lawful arrest, to search the person and the area within their reach, without a separate warrant. The reasons are practical. First, officer safety. The police need to make sure you are not reaching for a weapon. Second, preserving evidence. They need to stop you from destroying something before it can be collected. Under that rule, courts had upheld searches of the things people carry: a wallet, a pocket, a crumpled cigarette package. So the government's argument in Riley was straightforward. A phone, it said, is just another item found on the person during an arrest. If the police can look inside a wallet, why not the phone next to it? But the court looked harder at what a phone actually is. A wallet holds a few cards and photos. A modern smartphone holds tens of thousands of messages, years of photographs, a browsing history, a calendar, location records, and access to even more data stored in the cloud. The two are not the same kind of thing, the court said. Not in how much they hold, and not in what that holding reveals. And much of what a phone reaches is not even stored on the phone. Tap an app, and you may be looking at data that lives on a company's servers, somewhere else entirely. By 2014, searching the device could quietly become a search of a life that is kept half in your pocket and half in the cloud. And the old justifications did not fit. The data inside a phone cannot be used as a weapon. It cannot cut an officer or help a suspect escape. The fear of evidence being destroyed could be handled in other ways, like securing the device. Strip away those two reasons, and what was left was simply the government wanting to read a person's entire digital life, on the spot because they happened to be under arrest. In 2014, the Supreme Court ruled, and not one justice dissented. The opinion was written by Chief Justice John Roberts, and its core was simple. The police generally may not search the digital contents of a cell phone seized during an arrest without a warrant. Roberts wrote that modern phones are now such a pervasive and insistent part of daily life that they hold in digital form the privacies of life. The sum of an individual's private life can be reconstructed from the device, where they have been, who they know, what they believe, what they fear. A search of a phone, he said, is not like emptying a pocket. Roberts pushed the point further. A search of a phone, he wrote, is not just larger than a search of a wallet. It can be more revealing than the most thorough search of a house. Your home does not carry a record of everywhere you have been, everything you have searched for, and every message you have ever sent. The phone in your pocket does. The court did not say the police can never see what is on your phone. It said they have to do what the Constitution normally requires for something this private. Go to a judge, show probable cause, and get a warrant. The ruling came down to 3 words that are now quoted constantly: get a warrant. This was not a brand new idea. It rested on a principle the court had set out decades earlier in a case about a man in a phone booth. There, the court had held that the Fourth Amendment protects people, not places. That what you reasonably try to keep private stays protected, even out in the world. Riley took that principle and carried it into the smartphone. Your phone is not a place the police have walked into. It is the most concentrated record of you that has ever existed. It is also why the court took 2 phones, not 1. Riley's was a modern smartphone. Worry's was a basic flip phone. By deciding them together, the justices made clear the rule was not about how advanced your device is. The protection attaches to the phone as a category, the thing almost everyone now carries, not to the model in your hand. The court left one important door open. In a true emergency, a bomb, a kidnapping, a child in danger, the police can still act without waiting for a warrant. The rule protects your phone. It does not turn it into a shield. Riley was the first time the Supreme Court looked squarely at the smartphone and said, "This changes things." The old rules written for pockets and wallets could not simply be stretched over a device that holds your entire life. But notice how careful the ruling is. It protects the contents of the phone, the messages, the photos, the files you can see when you unlock it. It assumes the private thing is the data you put there on purpose, and it still leaves room for emergencies, for consent, and for the warrant the police can always go and get. Think about what is actually on the device the court was protecting. Not only photos and messages, but the apps that quietly reveal the most private corners of a life. What you pray to, who you love, what illness you are reading about at 2 in the morning. The court did not need to catalog everyone. It only had to see that, taken together, they add up to you. What it does not fully answer is the harder question hiding underneath. Your phone does not only hold what you choose to put in it. Just by being on, it is constantly creating new information about you and handing it to someone else. Every few minutes, it tells the nearest tower where it is. You never type that, you never see it, and it does not stay in your pocket. It goes straight to your phone company. Riley protected what is inside the device. The next case would ask who owns the trail the device leaves behind. David Riley's case began with a traffic stop and ended with a rule that touches everyone who carries a phone. After 2014, the most personal object most people own could not be cracked open by the police just because they had been arrested. For that, the police need a warrant. But the protection had an edge to it. It guarded the words and images you placed inside the phone, the things you knew were private. It said much less about the information the phone produces on its own, automatically, and sends away without asking you. And the most revealing of all those automatic records is location. Your phone keeps a quiet, continuous log of where you are, day and night, and stores it with your carrier. If the police want that map of your life, do they need a warrant? Or did you give it away the moment you turned the phone on? In 2018, the court finally answered. That is next time.